Unmute. We're all unmuted.
They're all unmuted, yeah.
Good afternoon. My name is Maggie Blay. I'm one of the counselors here at Reliant, and I'm happy to introduce Jerry Jeswald. He has done many, many trainings for Reliant. He has been with Serenity Lane here in Oregon for 35 years, and he's going to be talking to you about reasonable suspicion. Thank you, Jerry, and welcome.
Thank you, Maggie. Well, good afternoon. You'll notice that the title on the title page is Managing Workplace Problems, Behavior Problems in the Workplace, the Challenge of Substance Abusers. If you can handle substance abusers, you can handle any kind of a problematic. In fact, a lot of the content that you'll see today is relevant to any kind of a performance deficiency. So that having been said, let's go ahead and advance, maybe. It's not going. Technical difficulty. We'll be advancing the slide. Oh, that's the other thing. We got to go to mute on the sound. So did you mute? Okay, so maybe. Yeah. Okay. So we'll start with an agenda. Basically, no, it did. There's a sound. It may not come across. So just some basic background information regarding current trends, the importance of following process. Obviously, that's the procedural part of any kind of a policy and procedure. I think everybody knows what the rules are. Problems occur when supervisors aren't real clear as to what they should do. So we'll talk about that. We'll talk about supervisors' roles and responsibilities. It's important to recognize that what we're talking about is managing risk in the workplace. Anybody that's got a substance use disorder is going to come to work sometimes in an impaired state. And when that happens, there's a duty on the part of the employer, and the supervisor is an agent of the employer to try to intervene with that and correct it. We've got a 5-step strategy that we'll cover, and that'll come later. And then the number one thing to avoid doing, and if I were in a class action, or I mean an actual live class, I'd be asking that question, and somebody would eventually say nothing, because that's the thing that will get employers and supervisors into the most trouble. And there's a lot of reasons why they do that. Oregon employers, about 60% of them, when asked if they could have a concern about this issue, respond with an absolute yes. Oftentimes, there are employers that have had situations in the past that have gone in a bad way, so we want to try to avoid that. If we take a look at the scope of the substance use problem in the state of Oregon, Econo Northwest did a study back in 2006. It's estimated to be somewhere in the neighborhood of $5.6 billion. That equals approximately $1,600 per person. So it's in a very expensive. This study probably got the attention of the legislature in terms of the economic impact, adverse impact, more than anything else. Alcohol abuse in Oregon, we've heard for a long time now that the taxation of marijuana is going to fix our debt problems and such. The adverse effects on the economy with the taxation of tobacco and alcohol. Alcohol is the one that's on the screen right now, but they're both 8 times greater than the actual revenue that's generated by the taxes. So it's not a good deal. In the state of Oregon, how do we compare? 17% of the emergency room visits are individuals that are actually seeking drugs. We're number 1 in the methadone overdose deaths. We're number 1 in the non-medical use of prescription drugs, opiates in particular, by 13 to 18-year-olds. That's a scary thing in itself. And Oregon was recently ranked as number 3 in the abuse of illicit drugs. I over the years, have characterized 4 things that really apply to those people that suffer from substance use disorders. 1, once you get into that kind of a situation, you can't go back to a controlled social use. Change is always preceded by some kind of a crisis. Anyone out there that has known someone that's accessed treatment, you know it's because something has happened. There's been some kind of a critical incident or something that has interpersonal relationships, legal consequences, their health can deteriorate. There's going to be something that comes to the attention of the individual before they're actually going to seek help. It's the only medical condition known in modern medicine that's actually diagnosed and treated by the individual. We can diagnose it with using the DSM-5 as a basis for making that diagnosis, but unless the person is believing the accuracy of that diagnosis and doing something about it, it oftentimes doesn't change. And then an active substance use disorder is always supported by others. I call them aiders and abettors. And when enough people stop aiding and abetting, there are only two things that can happen. The person's going to experience the crisis and do something to make that change, or they're going to go find somebody else to take the place of whoever's been providing them with that aiding and abetting. So why do employers implement drug-free workplace programs? It's economic. Basically, you know, unfortunately, a lot of that comes out of crisis again, but it's legislated. The federal DOT program, other kinds of federal programs, Department of Defense, the military, et cetera. It's kind of dictated that you have to have a program. Insurance incentives, the late 80s, early 90s, insurance companies started seeing the data coming in that showed that the recordable lost time injury accidents were reduced by between 25 and 75%. And the insurance companies didn't say you have to have a drug-free workplace program. They just said, here's your premium with the program, here's your premium without. You make the decision. And a lot of companies at that point decided to have one. And then unfortunately, there's some kind of a workplace crisis. And I get an awful lot of calls over the years after the fact. And obviously that crisis can't be fixed. And unfortunately, in two cases that I can think of, it was a door-closing event. The employer had allowed the person to continue to work well impaired, even though there had been several employees that had kind of called it to the employer's attention. The incident occurred, causing another employee their life, and that company was out of business. So as a manager, as a supervisor, getting down to the nitty-gritty, and I want to I will introduce a concept. I don't see this training as a training to teach people how to be drug-sniffing dogs. My goal and orientation is more to approach the issue from a fitness for duty standpoint. The best example that I can give you is the difference between, there is no difference between somebody that comes to work under the influence of alcohol and somebody that comes to work with a low blood sugar. In terms of their disorientation, their inability to function at a high level, they're just as much at risk as it relates to that. So it's important that the supervisor understands that they have a responsibility to deal with performance and behavioral problems. They don't have a responsibility for solving those problems. That's why you have Reliant Behavioral Health. It becomes an access place for individuals that are going through difficult times to get some support and help and the necessary services that they need. It's important to address situations in an objective. Everybody knows what objective is. It's factual. It's measurable. The timely piece is the piece that comes up with the fitness for duty. You might have an employee that comes to work 10 out of 15 days or 12 out of 15 days and they're fine, but the 2 or 3 days that they come to work and they're questionably fit for duty, that requires an addressing the issue right now, not waiting a week or not waiting a few days. And then it's all couched in reducing risk and increasing safety. The 5-step process that we'll be talking about is direct observation, documentation, and any of you in HR out there will be saying that documentation is the most critical element of this 5-step process. Without documentation, as the saying goes, it didn't happen, even though it did. And that sometimes frustrates supervisors because they haven't adequately been taught how to constructively document, and so therefore they do it wrong. They take it to HR, and HR looks at it and says, we can't use this. You're going to have to do it over again. And that's kind of part of what perpetuates the mindset on the part of the supervisors. Why go to HR? And there's going to be a philosophical message that I'm going to have throughout the remaining part of this training, and that is that getting supervisors to share the risk is a prominent goal of any kind of training that I do. I would much rather have, and I think HR folks would much rather have somebody come into their office, tell them about something that's going on, rather than find out post-incident. And again, those of you in HR out there know that many times you'll have an incident, you go to investigate, and there's stuff that's disclosed that should have been dealt with a long time ago. So we want to try to avoid that. Preparing to take action and then taking action are the next two steps. And then the fifth step is an important one as well, and that's following through and determining whether the changes have occurred. Casey Stengel, who was a Major League Baseball manager, said the key to being a good manager is keeping the people that hate me away from the ones that are still undecided. I think anybody in a leadership role out there can relate to that. We're not, there to be friends. We're there to be leaders or mentors and to guide folks into, doing a good job and also being safe. Current trends in the workplace, the abuse of alcohol on and off the job, that's still an issue. Prescription drugs, OxyContin and oxycodone. There's a new drug out there called Zohydro. The FDA approved that about a year ago. It's said to be 5 to 10 times stronger than OxyContin. The FDA has an advisory panel of 13 experts. 11 of the 13 advised them not to approve this drug for prescribing. They went in the face of and flew in the face of that, and they authorized it for release anyway. Methadone for pain management. My advice there is that any doctor that recommends methadone for pain management, get a second opinion. Methadone is extremely addicting. We've used it in the past for replacing heroin, putting people that are heroin addicts on methadone maintenance programs. What a heroin addict will tell you is that it's harder to get off of methadone than it is heroin. So going back to that doctor that's recommending methadone, you might just suggest that to yourself that what he's really suggesting to you is heroin. And I think the mindset there is going to be one of, I don't think so. I don't think I'm going to do that. And then there are other kinds of anti-anxiety medications, marijuana for pain management, and now we have marijuana for recreational use. We're live now in the state of Oregon. People can possess and use it in private. And most employers, I will say, are going to take a zero-tolerance approach. It's a real automatic thing if you're having to answer to the federal government or any federal entity, such as CDL drivers. Hospitals who are receiving Medicare and Medicaid payments are going to maintain a zero tolerance. The interesting paradox, however, is that the Board of Nursing won't take any adverse action against a licensee that tests positive for THC unless there's been evidence that they've been impaired at work. They're going to treat it the same way they do alcohol. Anyway, that's going to remain to be seen. All drugs have secondary side effects, prescription drugs, illicit drugs, and it's the secondary side effects that are the problem. If you listen to a 30-second commercial on a prescribed drug, 5 seconds will tell you what the drug is. The next 25 seconds will tell you disclaimers and side effects. And if you've not paid attention in the last 2 to 3 years, the FDA has ordered the pharmaceutical companies for full disclosure. And you'll hear words like fatal, death 2 to 3 times in the 25-second portion of that informational commercial. So paranoia, anxiety, depression, drug-induced psychosis, antisocial behavior. These are all things that are going to be manifested by what that drug is primarily doing to the brain of the individual that's taking that drug. Possible indicators of stimulant drugs. There's really 3 categories of drugs: stimulants, depressants, and hallucinogenics. And some of the possible indicators of a stimulant drug, and we've kind of come out of the methamphetamine, although it's still there. It's still being abused. You'll see people with kind of angry, aggressive behavior, paranoia, difficulty staying focused. In many cases, because of the way they operate, they'll look like they're doing a lot of work with it, but if you pay attention to what they're doing nothing productive. It's all repetitive. Unexplained bursts of energy, dilated pupils, excessive talkativeness. These are all indicators of possible stimulant drug use. Possible indications of depressant drug use: bloodshot eyes, flushed complexion, slurred speech, unusually loud, odor of what appears to be alcohol, and that odor can occur, a day after when the person's perspiring. The odor can come out in the perspiration, and it can smell like they're drinking. If they did a breathalyzer, they'd be a 0.000. We were talking before we got started here, and the federal government did a study about 10 years ago, and the number one impairing issue around substances in the workplace is hangovers. And people coming to work, they don't have any measurable amount of alcohol in their blood, but they're not functioning at a very high level. And then constricted pupils, which is the opposite of the stimulant drugs. And again, hallucinogenic drugs, confusion, inappropriate laughter, not following safety protocol, disheveled appearance, dilated pupils, again, possible indications of hallucinogenic drug use. Here is the important, an inability to focus. Here's the important point. These symptoms can be caused by other things than drugs or alcohol. The symptom still requires us to pay attention to the possibility of the employee being questionably fit to perform safely. That's what it's about. So when we see some of these performance deficiencies, we need to address them, we need to gather them, we need to document them, we need to sit down with the employee and make notice of what we've noticed or make public what we've noticed with the employee. If that's not done, the employee is going to be under the false impression that nobody even knows. And I can tell you many times where that's been the case. The employee didn't even think that the employer knew, and yet there were employees that were sitting around wondering when somebody was going to do something. What I can tell you is that after the crisis, after the event, and we've had 2 or 3 that were fatalities, we've had employees come out of the woodwork and saying, yeah, we told the manager, we told the owner of the company, we told the management, and unfortunately, once the event occurs, it's too late. And like I mentioned earlier, there's been at least 3 cases that I've had in my 35 years where that was a going out of business sale. It did them in. So what gets in the way? Well, there are a lot of things, but whoops, getting my. One is lack of clarity regarding procedures. As I mentioned earlier, everybody knows what the rules are, but when it comes time to enforce those rules, there's questions of doubt. And what I have learned over the years is that when supervisors are confused or unsure of what to do, they don't want to do the wrong thing, so they do nothing. And then all of a sudden you have a crisis and you start learning that there were things going on for quite a while. No skills in handling conflict. The best way to handle conflict is to not engage. And when that happens, there's a transition that occurs from the employee trying to incite the conflict to one of not being able to work their magic, if you will. Whereas when they're home and they get into an argument with their spouse, they can see the spouse as being the problem. It's not them. Not wanting to get anybody in trouble, possibility of losing the employee. Things have changed a little bit regarding that. There's a larger pool of available talent out there now than there was, although you're still running into a problem of accessing skilled labor. The skilled labor situation is candidly a crisis. So it limits your ability to actually produce goods for sale. How come that's not?
Oh, you're clicking.
There we go. And then the other one is the fear of being wrong. Again, if I'm wrong, what do I risk in terms of being sued for harassment or that sort of thing. What I can tell any supervisor that's out there in my 35 years of doing this work, the far greater risk of being sued is for negligence. It's not for invading privacy or doing something wrongful. I think the natural tendency is to wait far too long. That doesn't mean that you want to jump them either. As I mentioned earlier, I'm not here to teach you to be a drug-sniffing dog. The purpose of this training is to teach you to not ignore the kinds of obvious indicators that if something were to happen, other people would look at those indicators and say, what were you thinking? That's what you want to try to avoid. So here's the key. As the employer, the responsibility is to promote a workplace that is safe. In a second here, I'll have a slide that identifies the supervisor as an agent of the employer. What that means is that acting as an agent of the employer, you're obligated to promote this mindset or key concept of a safe work environment. So when somebody is presenting at work and they're questionably fit for duty, there is a responsibility on the part of the employee or the supervisor to either share that risk or to identify that problem behavior and make sure that the employee is aware of the need to change or to correct that. I didn't mention this earlier, but if you are dealing with somebody with a substance use disorder, you're dealing with somebody that's emotionally about 12 years old. So they may be an adult chronologically, but they may remind you of your teenage son or daughter because of their immature nature and their high-risk choices. So what you can do, as you do with your children, as your adolescents, is you can give them feedback, you can give them choices, and you can give the appropriate consequences. What you can't do is you cannot make that individual change. Ideally, if we're presenting things in a fashion that opens their eyes to see the detrimental conduct or the detrimental effect on the workplace, they will want to change. I've oftentimes said, and it's kind of the concept of good leadership is getting people to do what you want them to do because they want to do it, not because they feel like they have to do it. And that has a lot to do with how we frame things, how we present things, and how we hold people accountable. The typical scenario is one where we let it go for so long, and then as a result, do it again. And then as a result, the employee is surprised that you're even talking to them about anything because in their mind, everything's been fine. Try to keep it in one place. So the supervisors tend to either underreact or overreact, and typically the first response is one of underreacting, ignoring, hoping it'll go away. As it progressively gets worse over time, there's a tendency to then overreact. Now again, we're talking about an employee that maybe has a chronological age of 45, but an emotional age of 12. So we want to try to operate or function from the middle of these extremes so that we're dealing with more of a real expectation. We're really, the employee, many of you have, I'm sure, heard the situation of, when an employee, a good supervisor is going to have both good and challenging things that the employee needs to be aware of. We're not just hammering them on the negative stuff. We're letting them know when they're providing, a good work day. And again, that's going to promote a more willingness on the part of the employee to change, in my opinion. So legally, here we have that concept that the supervisor is an agent of the employer. What that means is that the supervisor, in acting on behalf of the employer, we've got all these written policies and all these written procedures, but if you've got supervisors that aren't following them, basically they're putting the employer at risk. There are some attorneys out there that will tell employers don't have a policy, because if you have a policy, you got to follow it. And especially any of you that might be union represented out there, it's one of the things that union representation will look for if there's any discrepancy about similar situation that's been handled two different ways, because whichever is the lower or the more accepting consequence is the one that you're going to have to live with. So in being an agent of the employer, you got to recognize that anything you know, the employer knows. And it's amazing how things can come out. We've had supervisors that have asked, well, about a given situation, and they've said, no, that didn't happen. And then there's surveillance video that indicates otherwise. And they weren't thinking about a surveillance video. I oftentimes refer to supervisors looking as if they have a camera on their shoulder, because if that comes out, then, you know, number one, you've lied in saying that that didn't happen, and the evidence showing otherwise. So it becomes really important to recognize that as an agent of the employer, your actions reflect on the employer. And then here's the concept that I was talking about, fitness for duty. Basically, it's a physical, emotional, and psychological ability to perform the job safely. And as was mentioned, it can be things other than drugs or alcohol that can contribute to a person being questionably fit for duty. The only reason I mention that is because when some things come up and we're saying the person's questionably fit for duty, if there's enough indicators there, it may warrant a drug screen or an alcohol breathalyzer to establish whether or not that might be a contributing factor. And one of the things that I like to think about when we're going to have to administer a for-cause drug or alcohol test is to disclose to the employee, we just need to rule this out. It's not that we're trying to hammer you, but we also need to manage the risk. So what we need to do is we need to rule out the possibility of drugs or alcohol contributing to some of these indicators that would maybe be possible of a person that's under the influence or has substances present in their body. The other thing that I want to make important note of here is that the supervisor is responsible. I'll ask this question sometimes in a live class, who's responsible for fitness for duty? And I oftentimes get the response, well, the employee is. Well, the employees, I've had situations in my career where people have been on the job with blood alcohol levels between 0.20 and 0.38. I don't want to be leaving it up to that employee as to whether or not they're fit for duty or not, because I can guarantee you they're not. The highest one was a 0.38. Our second highest was a 0.375, and I might note that that was a registered nurse in an assisted living facility that was tested for cause because she was making errors in the medications that were being dispensed to the patients. I didn't mention this earlier, but there are over 200,000 deaths a year due to two things, medication errors and allergic reaction to prescribed drugs. We don't have nearly that many people that are dying from illicit drugs, but we don't talk about it much. You are seeing more and more public service announcements about prescription drugs and the need to be careful with them. Mixing drugs. And my mom, who passed away some 5 years ago, before she died, she was on 11 different medications, and half of them were to offset the side effects of the first half. That's not right. So that's just my political statement. So negligence as a supervisor, which is the thing that I'm saying we need to be the most concerned about, basically you can be considered negligent if you had prior knowledge, or it can be established that you should have had prior knowledge and may have been able to prevent a harmful event by acting in an appropriate and timely manner. The should have becomes kind of a difficult one, although we've had situations where individuals were driving company cars without a valid driver's license. Now, is that a should have known? The state would say yes, it is. That's something that's publicly accessible, public knowledge, and the employer should have known. Some of the employers out there that have employees that have as part of their job description to drive either a company car or their personal vehicle on company business will contact DMV, and once the DMV is aware of the fact that that's part of their job description, if they are cited for, let's say, a driving under the influence charge, the employer will be notified of that. I might add that it's not necessarily the next day. It could be a week or 10 days or 2 weeks before you're notified of that, And as an employer, on the should have known factor, you're liable for that during that period of time. One thing that some employers are doing, like we have done with the prescription drug category, is that it's up to the employee to notify you if they are on a prescribed drug that has any kind of a cautionary warning regarding functioning cognitively. Some employers are going to the fact where individuals, again, are driving on company business, that if you receive a citation that adversely affects your driving privileges, you must notify us within 24 hours. And failure to do that, at least, then puts the employer in less of a liability position because you're guarding against that. And if the employee doesn't notify you, you're less liable. And then reasonable suspicion. The way I describe this, if you presented your evidence or documentation, this is for now private employers. Public employers have to rise to a higher standard than public or private do. But if you presented your documentation to a group of people, if over half of those people concur with the action that's been taken based on your policy and procedures, or if you have unions, labor management contracts, then you have met the threshold of reasonable suspicion. Years ago, I remember employers proudly stating that everybody that they had tested for cause tested positive. And my response to them was, you're waiting too long. If you're not testing that person when some of those indicators are presenting themselves, then you've got some risk between knowing that and an incident that could occur. And then the other way I like to look at that as an example is if the information about your knowledge were in a newspaper after some kind of a adverse event, would you feel bad for not having taken the appropriate action? This is where I say share the risk. When you've got concerns about somebody being questionably fit for duty and possibly being impaired, at minimum, I would hope that after this you would at least knock on the door of somebody above you and let them know what you're aware of, rather than them finding out after the fact of some kind of an incident occurring. That's an important point. Share the risk. So the 5-step process, revisiting that, observing, documenting, preparing, taking action, and following through. I think of these as being spokes to a wheel. The spokes support the wheel. All 5 steps, with documentation being the most important, are critical for the process. And in the event that you skip, some of this, whoops, I'm not sure how that, let's go back if we can. In the event that you do skip one of these steps, then basically you're opening the challenge, the likelihood of a successful challenge. You've got to present the evidence that substantiates why you did what you did, whether you're taking somebody off the job or whether you're actually, maybe even in some cases, if it's an egregious enough event, you're terminating them. If that's challenged, then you've got to present the evidence that shows that you did your due process and it wasn't something that you did egregiously against the employee. So the good documentation basically is going to consist of answering the questions of who the individual is, what took place, where it took place, when it took place, and how it affects the organization. Specifically, the how is probably the hardest question up there for anybody to answer, but what that's going to construct is what you'll see in a slide or two from now. What is it that we're concerned about? What are our expectations? And what are the possible consequences going to be? That's the duty of the employer, to make sure that the employee is adequately informed. That's why we have a policy, for example. It spells out, that society has a problem. We can only assume that some of that problem is going to, present itself in our workplace. That's our concern. Our expectation is that if you get tested, you have no substance, foreign substance in your body. And thirdly, if you do, that's probably going to cost you your job. So that's the concerns, expectations, and consequences. Therein lies the question how. The question that's not asked is why. Our job is to inform the employee. The employee's job is to respond to a reasonable request. not coming to work with a substance or impaired in any way, whether it's a medical condition or a drug or alcohol, is something that they can control or they can not do. And it's a reasonable expectation on the part of the employer to have them do that. The 5-step strategy, again, skipping a step increases the risk of a successful challenge. I thought that slide was there. I just had it out of order, so I apologize for that. What is objective? Basically, it's what we see and what we hear. It's what would be on a videotape, and it's what all observers would agree to. It's measurable. It's factual. Again, probably the number one thing that supervisors have the most difficulty with is objectively documenting. They tend to draw their own conclusions. They have their own judgments or their own ideas of what are going on. And even though they may be accurate, they don't have the objective criteria to establish the accuracy of their conclusion. Good documentation, again, gives a clear, complete, objective picture. It shows why you took action, which is the most important point, and it becomes a legal record in the event that it is challenged and it does go to court. That doesn't happen very often, but as Murphy's Law goes, if you were adequately prepared 99 times out of 100, you know which one would go to court or would be challenged. Preparation step of the 5-step process, reviewing the documentation, the policy, the labor management agreement if there is one, and the employee's job description. Have they been adequately trained, for example? Asking for guidance, also what I call sharing the risk. I think there's a lot of things that get in the way of that, pride, ego, but I think if we can create an environment in which we have an open door policy and encourage that, that it's more likely to happen. And I think supervisors are willing to do that if they realize that they're not going to be criticized for it. And then anticipating the employee's reaction. If we're prepared for the worst and get the best, it's a cakewalk. But if we're prepared for the best and get the worst, that's when people kind of get thrown a loop and they get challenged. Some of the things employees will do, and you're familiar with many of these, they'll get emotionally upset. They'll make excuses, and you know the excuses that they'll have will probably maybe even put you in a place of, golly, I sure am glad I'm not that person. They'll apologize. They'll be very sorry. And the important thing to note, if you are dealing with somebody with a substance use disorder, they mean it at the time that they say it. The sad part is that they're not able to follow through. The other one that we're probably the most familiar with is that they'll get angry. They'll get upset. Why do they do these things? The answer to that question is because they work. They get people off balance. They get people to thinking, well, maybe I'm wrong. And so once you start getting into that place, they'll eat you alive. And so we want to try to present things. I'll have a slide here later on where once we've presented the facts to the information to the employee makes the choice. They either self-correct the behavior or they self-eliminate. I don't fire you, you fire you. And I think that's an important point to be made. If a person's continuing to do something that we've warned them against doing, what they're basically saying to you is, you know what, I really don't want to work here. And that's unfortunate, but that's sometimes the case. Supervisors, they'll do some things. They'll ambush the employee and verbally attack them. They'll avoid them. They'll argue with the employee. That never works. Not listening. Taking on the employee's problem. We say in the clinical field that if you're working harder at fixing somebody else's problem than they are, you've just taken on their problem. And they'll let you. And maybe even blame you for it not working. And then debating the existence of a problem or the reason for it. You just don't want to get into a debate with folks. Once that happens, they're in charge and they're in control. Be a good listener. Let them go ahead and go off if that's what they're going to do. Once they recognize that it's not going to work, they'll, again, dig into their bag of tricks from the previous slide, and they'll basically try different things to see if they can get you off balance. If you just sit there and listen and take it on, they'll eventually come around to either being totally frustrated that they leave or listen to what you have to say and make an effort to change. Meeting with the employee, I think it's important to, number one, be firm but be fair. Number two, focus on the conduct of the behavior, not on the reason for it or not on the person. There's a difference between the person and the behavior. The behavior is what we want to see change. If any of you are out there, and unfortunately, raising teenagers right now, you'll know what I mean by the difference between loving them and not standing them. Your heads, you can't stand them sometimes, but that's in conflict with your heart. You love them to death. And so they'll use that conflict between head and heart against you. And employees are no different. Remember, I told you we're dealing with a 12 or a 13-year-old here. Respect the employee, but definitely hold him or her responsible for improving. And when they make that effort and they do that, it's really critical and important to make note of it, to let them know that you've noticed. When that doesn't happen, that's the follow-through step. When that doesn't happen, they're wondering, why make the effort? It doesn't matter anyway. So, meeting with the employee, here's the agenda that I just mentioned: concerns, expectations, and possible consequences. I only use the word possible consequences, or the term possible consequences, much like we in our policies say discipline up to and including termination. It gives you a little flexibility. The only thing I will say is this: if you are absolute about what the next consequence is going to be, and you've established that with the employee, you must follow through. You must, at that point, if you're saying this is going to be a terminatable offense, if it happens again, when it does, if it does, you must terminate the individual. I've seen more employers get in trouble for that, saying that that's what's going to happen, and it didn't happen, and it is judged on the outside, either in an arbitrator or a judicial hearing, that you're more confusing the individual by continuing to give them last chances. Once it's become a last chance, it's got to be a last chance. Meeting with the employee, I think it's important to mention one or two of the employee's contributions to the workplace. Sometimes supervisors will tell me, well, I really can't think of anything. And I just say, well, then don't start with just the launching on the concerns and the expectations and consequences. Have some cordial conversation with them prior to moving on to the next step, which is, I do have 2 concerns that I'd like to talk to you about, 3 concerns, or 1, whatever it is. And then it's important in that step to ask the employee to make a commitment to listen to what those concerns are. They'll oftentimes give it, but then at the point where it's time to defend themselves, they'll interject, yeah, but. It's important to just remind them of the commitment that they've made and to continue on. Remind them that it's time for them to be a good listener. It's important for you to hear what they have to say, but that time will come in its due time. Did I do it again? I did it again. Sorry about that. I'm sorry. I'm glad you're here. State your observations and concerns. Secondly, or the next step, rather, is say, I'd like to hear what you have to say or what your side of it is. State where your expectations are. And probably the hardest one to bring up is the consequences. Stating what the possible consequences are going to be. And oftentimes I think a statement like, I really hope that we don't have to do that is sometimes a little bit of a softening to the idea of displaying or letting them know that if it happens again, they won't be here anymore. So it tells them 3 things when we say that. 1, if you continue the behavior, we'll go to the next level of consequence. We care about you, and we want you to be a part of this team. But third, and probably most importantly, is it's entirely up to you. You make the changes, you're a part of the team. If you don't, it probably is not going to be so. Stanford University did a study on effective communication. 93% of effective communication is nonverbal. The percentages go something like this. Words are 7%, tone of voice is 38%, and body language is 55%. 93% of effective communication is nonverbal, and yet we spend most of our time thinking about what we're going to say rather than how we're going to say it. It's a very critical piece of good leadership, good supervision. If we're expressing that we care about the person, our tone of voice needs to be in alignment with that. Our body language needs to be in alignment with that. And it may seem trite or insignificant, but it's a huge part of what good leadership is about. So once the employee is adequately informed, they make the decision. They self-correct the behavior, and we congratulate them on that and say, we've noticed that you've made the extra effort, or they give us further grounds for them terminating themselves. Let's put it that way. And I think it's important for us to recognize that, because that gets in the way. I think a lot of times the emotional part of this as a supervisor gets in the way of that kind of a consequence, because we start thinking about whether or not they're going to be able to feed their family, whether they're going to be upset with us. The reality is they're creating this themselves. If we're doing a good job of laying the groundwork of, where they are in terms of their performance and how they can improve that, and that we're reinforcing it when they make that effort, then it's kind of up to them as to whether or not they're going to continue to be with us or not. Excuse me. So here are the 5 steps again in a different form, in the form of the wheel. And all I want to recognize here is that it's an ongoing process. It's a process that moves. The wheel turns. So in good supervision, we're doing 1 or maybe 3 or 4 of those steps in any given day, or maybe even in any given half day. But we're basically doing a better job of being more objective, of presenting the facts in a way that will get a better response. So, in summary, before I move on to a couple of scenarios, when you have a concern regarding a possible violation of your alcohol or drug policy, document your concerns. Secondly, share your concerns with somebody above you. Do not diagnose. Do not think that you know what's going on. Follow the procedure in the contract language and refer for assistance. When we're doing that and somebody doesn't access the assistance, then they're basically doing what we call abandoning what we're offering them to help solve the problem. And they may do that. But they still have a job to do. We still have to measure whether that's being adequately done. And again, make the appropriate responses accordingly. A couple of questions to think about. What is the possible outcome of a supervisor not following company policy and procedure? I've told you about 3 cases where there were door-closing events. That's not usually going to be the case. It's typically going to be something less significant than that. Who in your organization can you share the risk with when you have concerns about unsafe behavior or work performance? That should be established beforehand, rather than the supervisor saying something that they're concerned about and then saying, what do I do or where do I go? And most of you, I'm sure, have that well in place. If you have an EAP, as you do with RBH, you've got a great resource there. So I'm just going to go through 2 quick scenarios, and then if you have any questions, I think, Maggie, are you going to accept those questions, or is somebody?
We'll check on the questions.
Okay, we'll check on the questions if you have any. Number 1, Lance has worked for the company or agency for the past 22 years. In less than 3 years, he will be eligible for retirement. He's been considered an excellent employee, and his performance reviews reflect that fact. 3 months ago, his wife of 30 years suddenly passed away. What concerns you is that Lance has recently appeared exhausted and been making errors in his work, which is unusual for him. Last week, you overheard him tell a co-worker that he's been having trouble sleeping. You also have heard rumors that he has obtained a prescription for a sleeping medication, but that's not something that he's reported, which I'm sure your policy addresses and calls for. So in this scenario, since I'm not going to get a chance to hear what your thoughts are, it's important to sit down and have a conversation with Lance. You've got some performance deficiencies there to initiate the interaction. That's one thing. The other thing that you have firsthand knowledge of is that you overheard him tell a coworker that he's been having trouble sleeping. The other issue around the rumor mill of him having a prescription for a sleeping medication is rumor, so you can't bring that up. What you could bring up with him is that I did overhear you say that you're having trouble sleeping, Lance. What are you doing about that? Lance may respond with, it's none of your business. Well, Lance, I just want to remind you what our policy is if you are on a medication. You do have a duty under the policy to report that to your supervisor so that they can better manage your fitness for duty. Now, you can either accept to do that or not do that. I can think of a couple of cases where in one case it was a fatality. The autopsy disclosed that the individual had methadone in his system and got run over by a piece of heavy equipment. The wife wanted to know why the employer had him in a high-risk work environment. Well, he hadn't disclosed that he was on a medication. So they had him actually in a situation that he disclosed that he was on a medication. The other important point to note in this is the supervisor cannot ask them what that medication is or what they're taking that medication for. That's a HIPAA violation. But the duty of the employee reporting any time there's a cautionary warning, the employee needs to be reminded of that in the event that they don't do that. Okay, so that's scenario number one. Scenario number two is a little more blatant. You supervise a long-term employee with, again, an excellent work history. In fact, over the time you've supervised, he's been one of the most dependable employees. Your concerns are that the quality of work has been slowly declining. He's been late for work 3 times in the past 4 weeks. He's told you that he and his wife for 20 years are separated, and she's indicated that she wants a divorce. The clincher is that you've got 3 separate employees that have confided in you that they've smelled what they believe to be alcohol when he first reports to work. This requires a much more urgent response, interacting with this employee to find out if you're noting anything that the employees that have told you about. This is the kind of a scenario where if you don't follow through, that when something happens, those 3 employees are in your face saying, this is exactly why I told you what I told you. Why didn't you do something? And again, these are crises that have occurred over the years, at which point the employer has a real hard time declaring that they didn't have prior knowledge. In one case, it led to a fatality, and there weren't 3 employees that notified the employer, there were 27. And in that particular incident, each of those 27 employees gave deposition to the attorney that was representing the estate of the person that was killed that, yeah, they had told the management. 2 questions, or 1 question was answered, are you surprised this happened? All 27 said no, and all 27 volunteered, we're surprised it took this long. You don't want to be the employer in that kind of an incident. That employee or that employer was out of business within a couple of months. I think we are there. The individual action plan really cause you to question what your personal strengths and weaknesses are. Most of the weaknesses fall in the category of conflict avoidance. The other one is fear of being wrong. Now I'm talking about the supervisor when there's a decision to possibly drug test. You know, they don't want to do the wrong thing, number 1, and number 2, they don't want to be wrong. There are environmental strengths and weaknesses. You know, where are the strengths within the organization that you can go to access, you know, support and guidance, if you will, in terms of what you should do and how you should go about doing it. And then what can I do to become more proactive? And you got a great resource in Reliant Behavioral Health and the EAP to coach you through things. So, again, the main thing is that we're not doing nothing, that we're addressing the situations. And I think we're there.
So we don't, oh.
There's one. We're catching a question or two, so we'll try to answer those.
3 employees have reported the email for alcohol. What discussion would you suggest having with the employee?
Okay. So in the scenario that the 3 employees confidently told the supervisor that they suspected that they might have, and you'll notice that in the scenario I said what appears to be alcohol, because we also know that, again, the diabetic could give off an odor of what appears to be alcohol. It would be important at that point to have a discussion with the employee in question regarding the fact that, number one, there's some issues going on. Number two, if I'm noticing that there's an odor of alcohol, I'm asking the employee, have you consumed any alcohol prior to coming to work? We all know what that question is going to be answered with, an emphatic no, because they know what the rule is. But in the course of interacting with that employee, more closely supervising that employee, you don't want to accuse them of anything. But if you're seeing 3 or 4 indicators that could possibly indicate intoxication, that's the point in time where you say, I believe we have grounds to request that you submit to a breathalyzer to rule out the possibility that you're under the influence of alcohol. So I hope you understand that. And they either might say yes, or they might say, I'm going to get an attorney, or whatever else they might say to defend themselves. It's just important that once you've made that decision, that you hold your ground. Don't be fearful. If you follow the process that we're talking about and the process that exists within your policy, you have not done anything that's of an illegal nature. They're just trying to throw doubt into your mind. And when that happens, that's when mistakes are made, frankly. Hopefully that answers that.
Okay, so we have one more question.
Okay, one more question.
What liability do we have as the employer in the employees driving their personal vehicle to and from work?
Question is, what liability does the employer have with the employee driving to and from work in their own personal vehicle? The only way that there would be liability is if, on the way to work, none, because you'd have no knowledge. But once that person gets to work and you suspect that they're impaired due to alcohol, and let's say you go with the conversation that I just suggested, and you say, I think we need to go in for a probable cause breathalyzer. And they blow you off and they say, I'm not going, I'm leaving. Now, at the point that they leave, you can't restrain them, but what you could do at that point, if they're leaving the premises, and in essence they're being insubordinate, you call the local law enforcement agency or 911 and indicate who the person, what the description of the car or the vehicle, the concerns that you have. We've had about 4 or 5 instances where that actually happened, and law enforcement stopped them and gave them a driving under the influence charge. So, because they were under the influence. So prior to coming to work, I would suggest no liability. Once you have knowledge that the person's questionably impaired, possibly due to alcohol, and they leave your premises, you do have risk of liability if you don't call 911 and report that.
Do we have time for one more question?
We do.
Okay. You mentioned that public employees were held to a higher standard. Can you elaborate on that?
Yes. As a public employer, under the Constitution, you have a higher protection, if you will. Therefore, where the more likelihood than not for a public employer, a private employer, I'm sorry, the public employer has to meet a standard that would be more like 8 out of 10, that have to establish that, yes, you did not invade the privacy rights of that individual. So it's just a matter of public versus private. Private has more leeway. The law really recognizes where the preponderance of the evidence is more likely than not to be what you suspect it to be. The public employer has to meet a higher standard due to the constitutional rights. Thank you, and good luck.
That's all we have.
That was great, as always.
Yeah.